The issue we are debating today is the government's duty to protect law officers' advice, which is in the national interest. This House has previously recognised the importance of the principle that information cannot always be disclosed. This is always guided by the need to protect the broader public interest. This is directly reflected in the Freedom of Information Act of 2000, brought in under a Labour government, which sets out a careful scheme for balancing the twin imperatives of transparency on the one hand and of safeguarding the public interest on the other. The consequences of not following those principles are obvious. The House might request, by way of a humble address, information that could compromise national security or which might put the lives of our troops in danger.
Obviously, parliamentary sovereignty and the duty of government to obey motions is extremely important to this House. But my honourable friend is rightly saying there's another problem of the confidentiality of legal advice, which Labour and Conservative governments also need as well. Isn't there a sensible solution to this, as opposed to this party political exchange at the moment, that the opposition agree to receive a confidential briefing on Privy Council terms, look at the documents, and have the attorney point out those parts which, in everybody's view, might damage the national interest, damage the negotiating position of any government of any party, and in effect agree to redact the documents, the politically embarrassing bits, which is what the opposition are after, and all the rest of it, they can come out. But with both these conventions, that the House must be obeyed and that the attorney's legal advice should be confidential, ought to be protected, and that's a possible way of reconciling the two.
Well, I'm grateful for the advice of the Father of the House, but he will appreciate that the Right Honourable Gentleman opposite wants all legal advice to be put into the public domain without any attempt at protecting the national interest whatsoever. And what he will appreciate, I won't give way for a while, the consequences of not following the principles of transparency on the one hand and safeguarding public interest on the other are very obvious. The House could request, by way of a humble address, information that could compromise national security. It would mean releasing information with no method for the House itself to review or assess the information in question before its full release into the public domain. It would not be possible under the humble address procedure to weigh up any potential consequences of such a disclosure. It is simply an irresponsible thing to do. Turning to the present case concerning law officers' advice. As this House is aware, this is the subject of very long-standing conventions which are enshrined in the Ministerial Code and recognised in Erskine May. Firstly, without the authorisation of the law officers, the fact that, or whether indeed their advice has been provided to government, should not be disclosed. Secondly, such advice must not be provided to those outside of government without the law officers' express authorisation. The purpose of these conventions are to provide the best possible guarantee that government business is conducted in the light of full and frank legal advice. This is a fundamental principle of the rule of law. If government knew that it might be forced to disclose the advice that it had received, it could seriously compromise the sorts of requests for advice that would be made, and it would totally impede the ability of the law officers and government lawyers to provide it. In turn, that would seriously compromise good government.